Good evening, everybody. I'm Barnaby Hone. I'm the Professor in Practice for the Institute of Advanced Legal Studies. I'm here today to present two very interesting speakers on the Bribery Act and where we are now. What the format of today will be is the two speakers will give a presentation and then we'll have a question and answer session afterwards, where we'll have an opportunity for you to ask questions. I might ask some questions myself about both the talks and about the Bribery Act and its international ramifications. First, if I could just introduce Professor Tina Soride. She is a professor of law and economics. Her research is focused on corruption and governance, markets and development, currently with an emphasis on the law enforcement. She's previously been employed by the Faculty of Law at the University of Bergen and at the World Bank in Washington, DC. She's currently with the Norwegian School of Economics. At the NHH, as it's called, she teaches courses in business, ethics, corruption and governance, coordinates a student mobility program in anti-corruption with schools in Ukraine and Georgia, and organizes a research program on corporate compliance and enforcement. She's vastly published, including Criminal Justice, Bridging Legal and Economic Perspectives. We have as our first speaker, Monty Raphael, Queen's Counsel. He is one of the leading fraud lawyers and is special counsel at Peters and Peters.
Was,
do apologize. I'm afraid I took your profile, I think, from Peters and Peters, so I do apologize greatly. He gave evidence on the draft bribery bill to the House of Commons Joint Committee and is editor of Blackstone's Guide on the Bribery Act 2010.
And one other book.
My apologies. You'll be
Don't worry about it. I'll spend the first half of my time catching up with my CV.
If you give us a brief overview of your CV, of course, and then go into your talk. Monty, I'll hand it over to you.
Thank you very much indeed. Good afternoon, everyone. Thank you, Barnaby, for that. Never mind about my CV. If you have a very good screen in front of you, you can see I'm extremely old. Assume that I've been doing this for a long time. In fact, I practiced this area of law, white-collar crime, for 60 years until I retired in 2018. And I still keep an interest in it in various ways. And indeed, I've written about it and so on. Let's go back a little way. Let's go back, for some of you who were alive then, to something like 2008 or 9, when, can you still see me? Yes?
Yes, we can.
Okay. 2008 or 9, when the Law Commission eventually provided its final report into reforming the law of bribery. And the government, the Blair-Brown government, appeared to be enthusiastic about introducing a bill, and it all looked amazing. And we'd waited a long time. I, in common with every other living person in the UK, had waited some 104 years for the law to be reformed. Last reform, the Prevention of Corruption Act, 1906. There had been lots of false starts, a lot of pressure, as we hear in a moment, from external bodies, the OECD being one of the major ones, NGOs, of course. I was then very involved with Transparency International, and so on, other pressure groups. There was never an enormous amount of enthusiasm about reforming our law, particularly not as far as criminalizing the bribery of foreign public officials was concerned, because we actually, between 1906 and 2010, we only apparently prosecuted one person for bribing a foreign public official. It doesn't show an immense amount of enthusiasm, does it? And that took a long time to find that case, because when I presented a paper to the OECD when they were debating the formation of the convention, I was asked point blank by the American head of delegation, well, how many cases have you prosecuted? And I had to say shamefacedly, none. But that's eventually somebody in government found this other case. Anyway, so there hadn't been a lot going on. Of course, we had domestic bribery laws and we had bribery cases, but the big grand bribery had somehow passed the UK by. So it was very exciting. We had a new act. This act didn't just reflect the OECD, because the OECD, remember, the OECD Convention is really a transposed Foreign Corrupt Practices Act. If you look at it, the model is the FCPA. It emerged in Paris in the OECD because that's the only place the Department of Justice of the United States could find to put down roots. They had to put down roots, I'll explain why in a minute, was the OECD. They said, okay, come here, said Mark Pearth, and we will help you level the playing field. That was the expression. So they decided to have a level playing field. Otherwise, the world was being beastly to American companies, and it was only American companies who were being dunned for bribing foreign public officials, and all their competitors, the UK, Germany, France, Spain, etc., all getting away with it, and they were all making lots of money at the expense of the UK commerce. And so the OECD was there. The OECD eventually, we started off by saying to the OECD, we didn't need to reform our law because our law was perfectly satisfactory, even though it only scored no goals. But nonetheless, eventually we acceded to it. So in 1999, we actually signed the convention. Excuse me. Signed the convention, which was quite interesting by itself, Mr. Chairman, because we had no legislative power to actually transpose the convention. I may not survive this webinar, you understand that? Anyway, so eventually the criticism of the British government became so intense that they put 3 clauses onto an anti-terrorism bill and said, okay, now we have ratified the OECD Convention. So we're fully compliant. And away we went trying to get a reform of the law. So we had eventually, after several false starts, several law commission reports, several bills, we had a bill before Parliament in 2009, as you've kindly said. I was invited, among others, to give evidence to the Joint Committee considering this bill. Now, the great thing about this bill, or several great things about it, was that it swept up public and private corruption into a single concept. It didn't really make a big distinction, except in Section 6, dealing with the bribery of foreign agents, foreign public officials. But by and large, it tried to harmonise the whole thing. So in Section 1 and 2, they deal with the giving and receiving of bribes and so on. And then by the time you get to Section 3, you have to be a graduate in algebra, but you get there in the end and work out what's meant by all these concepts. However, big however, and that is that the legislation was there and it seemed to be okay and in line with what Parliament wanted and what the wider community wanted until we got to Clause 7. Now, Clause 7 tried to make up for a shortcoming in English criminal law, a shortcoming which prevails to this very day, which is we haven't found a clever way of prosecuting corporations, because it's very difficult to have a concept which is wildly different either from the one we've been using for more than 100 years, about 100, and to be honest, about 140 years, which is the identification principle, directly in mind, or going to the American model, which is vicarious liability. We didn't like vicarious liability because it was American. That's the first thing, the reason we didn't like it, which is, in my opinion, is a good enough reason. And secondly, it's fairly blunt. And so on, not terribly proportionate. We like the word proportionate in this country. We really do. And we try and introduce it into most legislative sentences or policy decisions. So we were stuck with the identification principle and we knew we had a problem. How were we going to prosecute corporations if we only had this blunt instrument of the identification? And so the final Law Commission report came up with a great idea. It said, okay, well, will introduce an offence in clause 7 of failing to prevent bribery by a responsible official. Somebody in the company is responsible for making sure bribery doesn't take place. That responsible official can be prosecuted if he doesn't adequately prevent it. Now, and if he doesn't and if he's negligent, forgive me, in failing to prevent it, negligent. So here we got Donahue and Stevenson is alive and well and is in the bribery bill, but that really didn't impress many people. It didn't impress the audience I spoke to in Parliament. They weren't terribly keen on it. They didn't really understand how it would work. I wasn't personally very keen, among many others, critics, because, of course, it introduced the concept of the reasonable man, how we were going to know what negligence was, what was the standard going to be, and so on. And we were a bit stuck because we could see the parliamentary time was running out. This was the end, remember, of the Blair-Brown Labour government. It was the last dying days of the Labour government, or dying months. So eventually, the legislators, Ministry of Justice and so on, were wise enough to appeal to a very distinguished academic, Professor Celia Wells from the University of Bristol, and she came up with this radical proposal. She said, we're never going to get around this issue. If the burden of proof remains on the Crown, we're never going to get around this. Let's have we'll deny it's a strict liability offence, but that's what it really is. And a strict liability offence saying the company is guilty if it fails to prevent bribery, or had adequate procedures in place to prevent bribery. And then, of course, there would be a defence, like all strict liability offences, or be a statutory defence, and the defence will be that they can demonstrate they did have adequate procedures. But that was quite a tall Everest to climb, and but the government wanted to get this bit of legislation through. They looked upon it as a bit of a talisman. They thought that would show that they were on the right road as far as criminal justice reform was concerned, and the Labour government could be trusted. They were going into an election, remember. So, in order to cure this impasse, there was a suggestion, it doesn't matter from whom, but it was a suggestion that we could deal with the problem of adequate. What does adequate mean? What does adequacy mean? Where's the definition of adequacy? And the answer is nothing. Nothing in this act, nothing in any guidance as such, which tells you what adequacy means. So they took a shortcut and they said, okay, we had guidance. We had guidance for anti-money laundering, so we can have guidance here. We're going to have guidance as to what is and is not an adequate procedure for bribery. Can I just tell you my personal view then, and which has remained the same, which is that it was a huge mistake. It wasn't a mistake to get a statute on the statute book. It was a mistake to say that there would be guidance, because I've always said that bribery is bribery. Anyone who is familiar with the English language knows the difference between bribery and not bribery. And what we were going back to was a regime of box ticking. Guidance was going to be there as a box ticker. And unfortunately, all my dystopian prognostications have come true. We have this enormous compliance industry now, enormous. And this compliance industry, which has given employment to many tens of thousands of people, it doesn't appear, does it, to have stopped bribery, stopped corruption. It's as ineffective, unfortunately, as our anti-money laundering rules, laws, and regulations have been. So companies could be compliant, but the problem is, for me, companies should be havens of integrity. That's why I'm happy to hand over that argument, if she wants to develop it, to my co-panelist, who's written and spoken about this as a distinguished academic expert. But for me, it's hopeless. Now, let me quickly move away from this for the moment and go on to the rest of the Bribery Act, because the House of Lords, the select committee that looked at this act in 2018 and 2019, reported in 2019, said it was wonderful, an absolute wonderful piece of legislation. We could be proud of it. We could be proud here. It was a world beater. You may have heard that phrase recently in other connections. It was a world beating statute. And what is it? There have been very few prosecutions for the main offences. Very few prosecutions. And such inquiries as have been concluded, most of the inquiries of corporate misconduct have ended in deferred prosecution. And we haven't got time to investigate any particular case, but this is the audience today made up of practitioners. They all know all the recent cases. Look at some of the big ones, the Rolls-Royce or Airbus. You end up with this terrible feeling, if you're as cynical as me after a mere 6 decades, that there are certain companies in this country that are too big to bring to trial. They can't, too big to fail is the other cliche. They can't. Look at what Mrs. Justice Sharp said about Airbus. Their conduct was egregious. However, there are only two large manufacturers of aircraft, civil aircraft, in the world. One is Airbus, the other is Boeing. And so this was a conduct which it was in 7 different jurisdictions over a very long space of time, involving millions and millions and millions. But at the end of the day, notwithstanding Article 5 of the OECD Convention, if you're not familiar with it, please look it up. I haven't got time to read it. Notwithstanding that article, which seems to say that you can't take into account economic reasons for not proceeding to enforce the OECD Convention or the statutes that emanate from it. Notwithstanding that, DPA for Airbus, DPA for Rolls-Royce and others. And so we've now had most of the cases coming out of the SFO since the Bribery Act came into force in the summer of 2011 have ended up as DPAs, most, the ones that have gone anywhere near a court. So if I'm asked whether I think it's a resounding success, no, I don't. Do I think Section 7 is a clever idea? Well, I think it's an idea which is better than the identification principle. I can see its merits, and I've always admired C.D. Wells' ingenuity in conjuring this up. But and of course, it's been extended by the Criminal Finance Act into the area of tax evasion. But and there are advocates for extending it further throughout the economic crime. I don't worry about that too much. I think we can't. Life is too short to worry for some perfect formula. So, somewhat reluctantly, I would endorse the extension of it into a wider area of white-collar crime and so on. Now, I think, Chair, I'm in danger of becoming so enthusiastic that I'll lose the ability to tell the time.
Please continue. You've got another 10 minutes if you wish. Well,
don't encourage me. I think you're going to get, and then you'll get a lot of applause from the audience. But anyway, I just want to go on with another couple of things I just want to mention about the Act. The strange thing is this: look at if those of you are interested academically from a professional point of view, look at the Select Committee of the House Lords that came to evaluate this Act. And look at how they evaluated and what conclusions they came to. I mean, I don't know on what criteria they fundamentally relied at the end of the day, because so much of criminal justice policy is political with a small p. Of course, sometimes it becomes political with a big P, but mercifully that's rare. But it's always political with a small p, because criminal justice policy is driven by the politics of the day. So we've got a situation here where we've got a serious fraud office that is producing endless deferred prosecution agreements and almost no trials, or no cases going through the complete system. And unfortunately, we're emulating the US, because in the US, they've been great. People keep saying they're an example to us for investigating and prosecuting white-collar crime. But of course, at the end of the day, it's very little jurisprudence there because most stuff is dealt with by plea bargains in more than 90%, and particularly in the area of white-collar crime, and particularly involving corporations. So there's no real jurisprudence. We don't actually have too much judicial pronouncements on the policy that society should have about white-collar crime. And is it a deterrent? Are DPAs really a deterrent? There's one other aspect I think maybe that my co-panelist, Professor Soredi, will deal with, and that is debarment. Now, debarment, of course, is a huge weapon. Just as revoking a banking license would be a huge weapon against a delinquent bank. And of course, it has a terrible effect on the economy. It has a terrible effect on people's lives, those who are serviced by the company, and mostly those who are employed by the company. And of course, it has a wider economic impact on the tax take. But at the end of the day, there has to be some declaration of intent by government. Either we're going to rein in corporations and try and control them where they stray ethically, or we're not. What we can't do at the moment is have a halfway house where we pretend to regulate companies, but actually when they're caught, which is not all that often, and very often nowadays with the assistance of whistleblowers rather than Sherlock Holmes' efforts, where they're caught, at the end of the day, society says to itself, oh, they're buying themselves out of trouble. And that's good. It's no good for society because it doesn't actually fully express society's disapproval. And of course, society is largely made up of individuals, not of corporations, and individuals can't buy themselves out. The awful thing about deferred prosecution agreements, as most of you will know, is that they were invented in the United States for individuals. They were never meant to assist corporations to carry on, but it's a tool that was appropriated by the Department of Justice in the States and borrowed enthusiastically by us in 2013. And it's been very good financially. The SFOs managed to gather up lots of money for our coffers. But at the end of the day, is it going to deter? Does it send a signal? Is it going to deter? I don't think so. Even I just want to say one last word. I hope that's encouraging to you, really. And that is this: all the corporate heat nowadays is on making sure that corporations have good ESG policies. Okay, so got to be environmentally correct, socially correct, and adhere to the very best governance standards. What you don't hear from ESG, don't hear from the big companies and other kind of organizations that are promoting a more progressive and engaged corporate ethic. What you don't hear is the word integrity. You don't hear them say, it's true, profit motive is not going to be the only motive in the future. We're going to have these other progressive motives, which is great. What they don't say is you have to have profit motive because otherwise no one's ever going to invest in a company. But you must try and build an ethical underpinning and foundation to the company. And that's not the same as saying we've got a very long and shiny compliance program. Thank you.
Thank you very much. Now, I look forward to asking some questions, and there's already been one question from the audience. If you could continue to write your questions in the chat or the Q&A, that'd be great. Hopefully we'll have more than one by the end of Professor Sorride's presentation. We have one quite interesting one as well already to expand on, but now I'm going to hand over to Professor Sorride. Professor.
Okay, thank you, Barnaby. I want to share my some slides. Let me see. So now I guess you can see both the slides and maybe me as well and hear me. Are things okay, Barnaby?
Yes, we can see the slides and see you.
Okay, well, thank you. And thank you for this invitation. Thanks to Colin King who organized this, and thanks to the Institute of Advanced Legal Studies. I am delighted to be here because I've been studying corruption since late 1990s, and I must say it has been very interesting to follow the evolution when it comes to how corporations are to be held responsible for bribery. So personally, I have my PhD is in economics, and I did what we call in Norway a postdoc. I had a postdoc position in criminal law. So this presentation is a bit colored by these different perspectives. And this event series, which is called Looking Back, Looking Forward, made me reflect a little bit on this legislation. And I think Monty had a very good overview, especially of the UK case. I will consider this a bit more broadly from an international perspective. And one of the things I find very interesting when we consider this evolution is how the legislation is, the evolution is not only a question of the scope and the clarity of liability, as it would be in many other areas of law, but since this evolution happened at the same time as many countries started to hold corporations liable, the evolution has also been very much about developing the enforcement mode. So these things must be seen in parallel, and this is why the discussions about foreign bribery legislation is also very often about the form of enforcement, and in many countries, so many countries after the 2000s, they started to hold corporations liable later than the UK, and in many countries they have not yet started to do so. So this is still in evolution. Now, let me see. So this is also very interesting because governments have mixed incentives to sanction companies for the ways they have secured contracts abroad. And Monty also touched upon the political side. And this is also why civil society has played a very important role when it comes to pushing for enforcement and for pushing governments to actually enforce these rules and not only sign, implement, and forget. So I think that is an extremely important point, and also this report Exporting Corruption from 2020 points at the fact that many countries are actually less focused on this form of enforcement now. So that is actually a serious concern. And when it comes to academics in all fields, 20 years ago, there were hardly any literature on corruption. And now all disciplines are involved, and there's a huge literature and many events like this, and which means these rules will continue to evolve with the help of academics. So personally, I have focused quite a lot on settlements, especially over the last few years. This is something I've done very much in cooperation with Abiola Makimba in the Netherlands. And we did, together with the International Bar Association, we did a survey of legislation and enforcement practices in 66 countries. The report is available online, and that gave us some understanding of how this enforcement is actually happening out there, because there's very often like a substantial deviation from what is written in the rules and what's happening in practice. And in parallel with that work, we invited academics, including Colin King and Stu Hawley, who have are part of this event series, and Colin King who organizes it. And we invited academics to help us understand the conceptual difficulties and benefits using this form of enforcement. So we call this negotiated settlements as an umbrella term, but this is basically about the DPAs that you know from the Rolls-Royce case and many others. So and this sort of insight is not only helpful for us; it's needed for for many policymakers, it appears, because in most countries there's no explicit rules on how such settlements should happen, and in many countries that enforce corporate criminal liability, they have not described this enforcement mode, and they still use it. So in such circumstances, it's very much up to the prosecutors to find a way to deal with this issue. And that became very clear in the Siemens case, which was settled in many countries around the globe. Those involved basically invented settlements as a tool for enforcing these rules. And the situation has changed rapidly. However, recently I did a study together with Radha Ivory, she's at Queensland University in Australia, and we tried to find out what the OECD and the UN say about how settlements should be used, because what we found when we reviewed 181 reporting documents, and these are the evaluation reports of how countries perform in terms of the way they enforce the OECD convention, the contents of that convention, and the UN anti-corruption convention, those tools that address foreign bribery. So when we considered all these reporting documents through by help of systematic review and document search tools, we found that the OECD does not really have a benchmark set of principles. They don't have a tool for estimating what is a good system. So when we studied what the OECD evaluators said about such values as justice, crime prevention, cost effectiveness, transparency, and participation in the development of the rules. When it came to all those values, the evaluation reports are very inconsistent. They tend to endorse the use of settlement. They say it is efficient, but they refer to it as good in many different ways, and they give a bit arbitrary advice on how, when it comes to how what governments should do to make this use function better. Now, the OECD is about to do something about this situation. So they have the ambition to review and revise the 2009 recommendations that are attached to the OECD Convention and develop principles. They review several different recommendations, and they now want to introduce recommendations for governments on how to use negotiated settlements, or DPAs, NPAs, and so on. They call it non-trial resolutions. That's the term applied consistently by the OECD now. And for this, and this is in process. This is happening now, and I have been part of a group that pushed for this result. It's called the Recommendation 6 group. That's a long story, but I will keep it short. But this is a group consisting of quite competent experts on bribery legislation, and consisting of civil society, lawyers, former prosecutors, academics. There's probably some names that you know on this list. And what we did, we developed a set of draft recommendations that show that this diverse group of experts could actually come to consent to some consensus. We could reach consensus on a set of principles that would improve the situation in most countries significantly if implemented for effect. And those drafts are available on several websites, including this one by the International Bar Association. We know that the OECD takes those into account in this when they now prepare recommendations. But I have several concerns. when it comes to the evolution in this respect. Among these, my concerns is that I'm worried that the recommendations that we will end up with will be a watered down version of the consensus that we developed in this group that I mentioned. Because what it means for the OECD to, if they are to develop recommendations, they will basically put constraints on their own flexibility, because the people who sit in this group of those who sit in the OECD working group, they are prosecutors, and as recommendations to make this this form of enforcement more principled in a sense will reduce their flexibility. But I do think many of them are absolutely interested in a more efficient and fair and transparent systems. So we are hoping this will change, and there will be a public consultation in December now. And so this is an evolution that is actually happening now. And countries will thereafter be evaluated upon how they enforce the rules with respect to such, whether they follow such recommendations or not. Of course, it's soft law, so it doesn't have any binding effect. Now, I'm also concerned because these settlements, as Monty also criticized, that these are happening in the shadow of the law, and that has several consequences. It means that there is greater room for political interference. And now, with the UK being a model country and having a model law, and the US and so on, this is something that is being exported to countries all over the world. And it is a very flexible form of enforcement. So I'm a bit worried how this can be not only used, but also misused around the world if countries want to hold corporations liable, because in some settings there is a severe threat for the companies that allegedly has been involved in corruption, and it can be very difficult not to accept an offer of ending the case with a fine. I'm also worried that the lack of case law will increase the uncertainty associated with trials, because if there's not enough cases, there will not be enough case law, and it will appear so unpredictable what will happen if the case is brought to court. So that will increase the incentives to accept a settlement. And also there is a risk of a slippery slope here, because the prosecutors, of course, they have incentives to secure the cooperation and well, incentivize cooperation and cooperation and get the case done and move on to the next. So it's much easier to have some sort of cooperation, and I'm worried that it becomes too cozy. In a sense, it can become too easy for companies to negotiate their way out of the problem, and too tempting for enforcement agencies to go after the individuals responsible once a penalty has been paid by a corporation. Now, when it comes to the government's disinclination to sanction that I mentioned in the introduction, and I want to say something more about that, and also some of the reasons why I'm worried that governments will not draw enough lessons from other areas of corporate regulation of corporate misconduct. And I'm watching I have a few more minutes, I think, Barnaby, right? So I want
time. Please don't worry.
Okay, thank you. I was a bit rushing. Now, so I've just done another form of research. This is an economic theory on the incentives to hold corporations responsible. It is an unpublished paper. So, and we study how government's incentives to enforce will depend on the profit-motivated crime in question, and how it will depend on the market concentration in the market, and whether the consequences of the crime materializes abroad or at home. And while this is an economic theory, we also reviewed 50 corporate liability cases in 5 countries, including the UK. And I must say it was extremely difficult to get information about the cases and to secure all the information we needed to evaluate the sanctions with the view of the market situation and whether this was a soft treatment or not. And you can see that in this table on the left-hand side, we have some cases and we have them listed with a height, whether the penalty was high or low, and that depends on whether there was so low penalty means that there is absolutely no chance that the penalty had a deterrent effect if we consider that in an economic sense, that it is crime deterrent means that it reduces the economic incentive to commit the crime. In the cases when there was a high penalty, we acknowledge that the penalty might have had such effect. And these letters at the behind the cases means, so the B, C, and L stands for bribery, competition law, and laundering, and the second is whether the consequences of the crime materialized abroad or at home. And so that's I and H. And what we see here is that even if these are only a few cases, so we cannot draw any general conclusions, but these limited case materials show that in the cases where the sanction appears to be low with no deterrent effect at all, it appears that these are the cases when the consequences of the crime materialized abroad. So this is a bit varying if it is a big if this is a general feature, and so that's something we should study more because it is extremely important that governments are responsible and also sanction properly when the problem happens internationally. And what we also found when we reviewed these cases is that, as mentioned, it was extremely difficult to find enough information about the cases because all these cases most of them are settlements. And for example, in my own country, in Norway, when there is a settlement, we only receive a press release about the case. Very often, it's not written by the corporation, but it is approved ahead, and it doesn't give the same information. If there is a court case, we get far more information about the offense, and that is a serious problem. And also, when it comes to the predictability of leniency, which is one of the benefits of using settlements, that corporations can be given the offer of reduced penalty. It's flexible in the sense that it is easier to reward companies if they self-report and cooperate. But those tools must be predictable to reduce the incentives for committing crime. There must be clear benefits for the corporation to self-report, and those systems they function far better when it comes to antitrust legislation than when it comes to bribery. That's a general feature. The good news for the UK is that the UK is coming out as the best performer in these respects compared to the other 4 countries in this survey. So these are some of the concerns with respect to the evolution. I also want to mention, this is from another study that is also work in progress because we study the implementation of the anti-money laundering regulations. And I just want to mention one of the things that we see when we go through all the evaluation reports, we see that even if this is an area where countries have cooperated in the development of the rules, there's evaluation of how countries perform. What we see is that performance is generally poor. And in some areas, for example, when it comes to mutual legal assistance and some other areas, we see that performance is actually worse than 10 years ago. So even if we have international cooperation, evaluation of performance and so on, it doesn't move consistently in the right direction. There can be serious flaws in the enforcement. I will not, I think I'm already spending most of my time. I just want to point at some of these insights. I think it is especially important to mention that for bribery law to function well, it is extremely important to combine it with the protection for whistleblowers. And that is a problem in many countries, including in Europe. Whistleblowers have a hard time, and also in many settings, it's harder for them than before. Very often the whistleblowers are attacked instead of the crime. But I think that the better the settlement, the enforcement systems work, the more predictable the leniency, the freer the press, the stronger are the corporate incentives to take whistleblowers seriously. But there has to be proper protection as well. I think I have mentioned most of these points. I think this issue about weak political willingness to act on foreign bribery, that is something that must be solved with more supranational cooperation and commitment. And so I think it is important to go in the direction of more coordination and not less. And that means also in specific cases, in order for companies to come forward and self-report, there has to be cooperation between enforcement agencies, and governments must, if they are not willing to enforce when problems happen abroad, then that's a case for supranational enforcement. So with these insights, I just want to end with this citation by Vinnie Bayanema. The rule of law, access to justice and financial transparency happen by design, not accident. And that means that failure might also be by design. Some of us have been in this game long enough to become a bit cynical. So we want, when we don't see true performance, we think there's a reason behind it, and definitely a need for action. So thank you.
Thank you very much for that very interesting talk. And both of you, thank you very much for all your insights. We now have another 40 minutes, which we hope we'll use for questions. I have a couple of questions which I'd like to just focus on, and also use the questions which are already in the chat. I'm sure if there's any more, please add them in for the participants. And I hope to put them to our two great presenters. The first one I wanted to start off in is the idea of too big to fail. And a point, Tina, you mentioned was some laws have been almost set up to fail, because some companies who are focused on bribery, as Monty said, and Airbus being one, have been almost seen as too big to fail, hence take the fine rather than prosecute them. Do you think that there'll ever be a time where bribery and the prosecution of bribery is more important than political considerations? And is that something which the OECD should build in to their benchmarks? If I could ask Tina for your thoughts on that, and then Monty for your thoughts around Airbus.
Sorry, Barnaby, you asked Monty first, didn't you?
No, I asked you first.
Oh, can you please, sorry, you said add several things. Can you please say exactly what you asked?
Do apologize. Do you think that the need for prosecution of benchmark cases, of big cases, which should override political considerations of companies being too big to fail, should be part of the benchmarking for the OECD?
Yes, I think it is extremely important to, as we saw in the Siemens case, going after big corporations is extremely important. I don't think there has to be the trial. It doesn't have to be brought to trial to enforce the legislation. I think there are many benefits with the use of non-trial resolutions, and you can combine such enforcement mode with deterrence if used in the right manner. And for very big corporations, that will often be an easier solution. So I'm not against that. I'm just critical towards the way it is used today. And I also think it is essential that the information that is provided in these cases are used by prosecutors to hold the individuals responsible, those responsible of the crime. It is important to pursue cases against them. And in many countries, that is seen as something that is done in a better way in a court case because those individuals' rights are better protected. So in many enforcement systems, criminal law functions very differently across countries, but in many countries they consider the rights of the individuals better protected in a trial compared to a plea bargain, while it can be the opposite in other countries. And regardless of how it is done, I think it is extremely important in the cases when companies are seen as too big to fail, or too big to jail, or too big to whatever. I think it is extremely important to go after also the individuals responsible, so that the crime is deterred also on the individual level.
Now, Monty, can I just expand on that?
Yes, please do.
Could you explain to us, from your perspective, why prosecuting companies rather than just accepting DPAs is important?
Well, you've asked some very profound questions, to which and Tina's raised some profound issues. And of course, I have no profound answers. Otherwise, I wouldn't be sitting here. I'd be selling it or bottling it. The problem is this: you have a free market economy whose very structure, its underpinning, is the corporation, and has been really since the beginning and middle of the 19th century. It's the focus of investment, the focus of development, the focus of employment, the focus of tax production, and so on. Security, even in the defense industry, etc. So you have the corporation isn't, as it were, standing out there by itself. It doesn't really have any peers. It's a unique creation and uniquely powerful. And as everyone on this call knows, there are now quite a few corporations in the world who are much more powerful than individual sovereign countries. They're certainly richer. So it's very difficult to know how you're going to rein these people in, other than by taking a great deal of time, as I said earlier, and increasing the integrity quotient. Now, can I just, I know, Barnaby, I seem to be sidestepping one of your questions, which I'm happy to do, but can I just tackle something that Tina raised? Because there'll be practicing lawyers listening to this webinar who will not necessarily agree with her that somehow corporations should be negotiated with, because they can't be sent to jail, so what's the point? And they can be negotiated with and they can be dunned financially, but the individual should be chased and prosecuted. That's not a universally held view, because it's a strange way of looking at the way corporations are organized. And major multinationals don't have their policy made by one or two men. They have their policy made in boards, in committees, and so on. That's the hard decision. And then there are a lot of soft decisions being made, or soft pressure is from shareholders, from the pension funds, and so on, and from activists to shareholders. They are squeezing the company all the time. So it isn't as if there are four people employed in Company X who are all the personification of Fagin and Bill Sykes. It doesn't work that way. It's much more subtle. And so, in a way, it takes away from corporate responsibility rather than enhances corporate responsibility. That was the whole point of not including negligence in Clause 7 of the Bribery Bill, because it focused on the individual. And Celia Wells, and I respectfully agree with her, wanted the focus back on the corporation. Try and make the corporation better. Don't have a system. You've got to remember, one, a real problem we have in the criminal justice system, Barnaby, that you and I and other lawyers would have always noticed very early on, and that is the criminal justice system is like the man who arrived in the bus station only to see the bus just disappearing around the corner. He's missing the bus. Society always misses the bus when it comes to crime control. It's very difficult to prevent it. So we're always stuck in these debates about how we're going to punish these people. Well, the answer is, if you're stuck like that, and we are stuck like that, you have to have some kind of fair system, proportionate system of punishment, and single out. Of course, there will be cases where individuals are the company. They're so overbearing, they have so much control that they are the company, and so they have to be singled out. I agree with that. But very often, in these big multilateral companies that I've dealt with and so on, over the years, there are 50 people making decisions or adding to the decisions. And at the end of the day, half a dozen people are singled out, or maybe another half a dozen of whistleblowers and so on. It's an unenviable and horrific way of going about things. The other thing I want just to say, stemming from your question and from Tina's excellent address, is this, that leniency, just think about it for the moment. We've got there are lots of leniency programs going around, and we've tried it in England, of course, in anti-competition stuff, and it exists in England informally and formally, and in the States and elsewhere. But just going back to what I said earlier about individuals, who offers the individual leniency? I mean, is some kind of community's sentence, is that leniency, or is it an appropriate reaction? Leniency means you really deserve greater punishment, but we're giving you less punishment. And I think it's questionable when it comes to individuals and questionable when it comes to corporations. But if we're going to do it for corporations, we ought to do it for individuals. In other words, we're creating this terrible division in society by treating corporations one way and individuals another way.
Well, thank you for that. I'm going to come back to the individual versus company in a point. There's a very interesting question about a Swiss law being changed. But if I can just go to Tina on one of the points raised by Monty. Sorry, that question's just gone completely out of my mind. I do apologize. Let me go back to, no, that's it. On your study that you did about different bribery prosecutions, did you look at any connection between how big a company was and whether it got leniency or not a harsh decision? Because looking at the table you put, there was quite an interesting Standard Bank was quite harsh, whereas Airbus, which had much more of a lenient decision, was much more of a core industry. So it almost looked like there was a connection between how many jobs were lost connected to how lenient the decision was. Is that something you've looked at, and where do you think that will fall?
Yes, thank you for the question. In this study, we wanted to see whether companies that had a lot of market power, if they were treated more lenient than others. And you can assume that if they have a lot of market power, they would probably profit more from the crime as well. So considering an economic idea about sanctions, they should have a much higher sanction than others. While we wanted to see if it appeared that they were treated more leniently. But considering these few cases, it seems that whether the crime happened abroad or at home was more important in that respect, and not market concentration. But we did not consider the size of the company per se. We we applied standard economic approaches for studying market position. So what we identified how exposed the companies were to competition. And one of the things that we will see is that if we have a very concentrated market, for example, if we have 2 companies producing COVID-19 vaccine for example, we don't want, so no governments would want to punish that corporation very harshly. So even if it profited enormously, it would not want to punish it as much as economic theories would suggest. So what we also see is that even if you have politicians who do take corruption seriously, they can have public interest concerns, and they may want to protect jobs, and they may want to consider a lot of other aspects. And in those settings, they will be more apparent in situations when companies have a lot of market power. So if you follow that logic, you may expect the big companies to be treated much more softly. So as long as you can become big enough, you will be protected simply by size, as was mentioned. So we wanted to check that, but we didn't see a very clear connection given the cases we found. But we did see that, well, the theory and the analysis shows that it's necessary to combine with other enforcement mechanisms, and if governments are not able to sanction corporations properly because they want to consider they have other concerns in society, then definitely it's extremely important to find alternatives and hold those involved responsible if they cannot hold the corporation sufficiently responsible because it's so big. I don't know if that answered the question, but at least there were some reflections.
Answers, reflections. I take everything in this area, but no, that really was interesting. I'm just going to another question which was asked by our audience about the importance of international cooperation in these matters, which from my own perspective is vital. I do a lot of that type of work. What I wonder is motivation for that is how much the financial consideration, how much bribery, how much fines can be recovered, and whether those fines are often shared between the wealthy countries, or if you think that there is a sensible way that it is actually the money is shared between the wealthy and the non-wealthy countries. I can think of a number of countries where less developed countries didn't share in the DPAs or any of the prosecutions. Do you think that's an important reform going forward? Monty, if I start for you and then go to Tina.
Well, yes, there probably is no perfect solution to this. I mean, from my own experience, going back 10 or 15 years, you remember we had rampant corruption under the rule of President Abacha, or General Abacha in Nigeria. And many billions were doubtless lost as a result of bribery or just straight theft. It was very strange because, of course, the actus reus, as it were, for the most part, was committed in Nigeria. That's where the money was generated and stolen from. But the Nigerian government appeared to be, I'm sure, very good reason, reluctant to, even when they could. I mean, they couldn't prosecute the principal defendant because he died in strange circumstances. But there were people who were subsequently pursued, and they didn't want to pursue domestic proceedings, but they were very content for other countries to do it, and they cooperated to a degree, but only on the undertaking that they were going to share the loot. In fact, what happened, for those who don't know the story, what happened was that Nigeria at that particular time had such a poor reputation for public probity that no one, once they recovered some of this money, that's still not recovered all of it to this day, once they recovered it, they refused to give it back to Nigeria on the basis that it would only be stolen all over again. So it was given to the International Bank of Settlements in Basel in reduction of Nigeria's debt to the international banking system. Now, or there's been other kind of remedial outcomes. For example, it's been used for developing social projects in Nigeria under strict regulatory restrictions. So it is, in a way, it's a difficult one to judge, and there's always an imbalance, isn't there? There's always an imbalance. I mean, when we settled the defence industry with one case, we got 30 million for the SFO. The Americans got $300 million, but nonetheless, a lot more than 30 million pounds. And this goes on all the time. There's this sort of arbitrage between countries. I think it's idle to believe that people will cooperate for any other reason than self-interest. I mean, I'm sorry about that. I'm too old to stop being cynical. I apologize to you and to Tina and to the audience.
You don't apologize. I've negotiated quite a few MOUs about asset sharing. There's never is it about our emotional ethics? It's always about how much money we're going to share. So you were talking to the converted. Sorry to disturb you.
No, not at all. No, that's the end of my profundity for that question. So Tina may want to come in. I don't know.
Well, Tina, can I ask you to come in? But also, there was an interesting question by Busy Bergella at the end from the audience about looking at there's a lot of enforcement of bribery in the developed countries, but there doesn't seem to be a good model for the enforcement of bribery and corruption offences in less developed countries. Is there any model that you would recommend? Is there any points which you think can be worked on by less developed countries to make a more transparent and better bribery and corruption legislation?
Thank you. Great questions. Well, I think to go to the last question first, I think there is a rapid evolution in many countries around the world. I think it's difficult to categorize countries according to developed or not developed because they develop in so many different ways. And what we see is that there are more and more serious enforcement agencies around the world. I'm just following a case with an Icelandic fishing company that paid bribes in Namibia. And that case is not, well, it doesn't appear to be much very seriously investigated in Iceland, but in Namibia, that case is investigated and they do it, they take it on very seriously, and it seems that the Icelandic company can be held responsible in Namibia. And I think that is a kind of evolution that we will see in the years to come, that more and more countries in Africa and also in Latin America, there has been a great development in the way corporations are being held responsible and so on. And I think we will see such developments in many countries. And this is also one of the reasons why it is so important to develop principles on how to hold corporations responsible. So that is one issue. And with more enforcement agencies involved, it is easier for enforcement agencies like SFO in the UK to cooperate with them and have and come to coordinated settlements with corporations, so that and the more coordinated settlements we have, the more likely corporations are to self-report, because then they will see an end to the problem if they self-report detected bribery in their organizations. So I think there are some promising evolutions. I'm not cynical all the time, but so I think there are some very positive developments. When it comes to sharing the fine money, one of my questions to you is that we don't know how much money there is to share. I have never seen a study of how much money is actually transferred to governments. So we see the press releases with all these big amounts, the fines, but also one of the things we see when we study settlement is that corporations use those negotiations. And now I'm not talking about the UK, but around the world, corporations also negotiate how to make those fine money tax deductible, how to pay over 30 years or something. So how big are those money how much money is there to share? But I think regardless of that, I think it is extremely important to consider how to work, how to do something for in the country if the problem materializes. somewhere else. And I think it's wise that some governments say that we want to share fine money if we see that there is some sort of investigation in the country where the corruption happened. So I know that is a strict requirement, but I also understand where it is coming from, because it is a problem if very huge amounts of money is transferred to a government that has no plans to pursue the problem. And so if it is possible to use it as an incentive, I think there is an idea. It has a value, but I know that there are also critics who say that is an unreasonable demand we should share in any case. But there are different ways of doing it. For example, in the United States, they have this kleptocrat program, so they try to pursue corruption in governance and politics around the world in different ways, and I think that is something that governments in the OECD countries could do in much better ways than today.
On the point of sharing, I think you're right. I think there needs to be sharing, but also targeted sharing. Looking at the Caribbean countries I've worked with, a lot of them have very good anti-corruption units. Their politics does get involved quite a lot, but they're also motivated by the money that they've recovered and the sharing of different assets. And a good example of how different law enforcement agencies are motivated by the assets they recover is the UK. With their rise of account freezing orders, they're now pursuing money laundering much more, partly, some would say, because law enforcement get 50% of all the money they recover, which, when you're recovering 350 million, is not a bad Christmas present. So I think you do see the balance in that, and the balance in enforcement issues.
Barnaby, can I ask you a question?
Just this once, of course.
Just going on from your statement.
Yes.
The problem about account freezing orders and similar sanctions and remedies is that they're non-penal.
But this is...
They're non-penal.
Yes, and this is the... Yeah, please.
Let me go to the second sentence. And therefore, they're non-penal, therefore they don't carry with them the stigma of a criminal prosecution or a criminal sanction, and they're another shortcut. What we've been discussing for almost an hour and a quarter now are a number of issues which, it's very strange. When I came into the profession, you either had crime or no crime. If you committed a crime and you were caught, you were punished criminally. Nowadays, what we've done is, because it's expensive and time-consuming to investigate crime and sanction it, and then indeed keep people incarcerated, that's where you're going to put them, because it's all to do with money, we've developed all these other strategies. We seize people's property, we freeze their bank accounts, we have civil forfeiture orders, we have all kinds of, well, of course, we have DPA, as we've been discussing. And many of them, you can see that the development in the last 20 or 30 years is do anything except prosecute anybody, investigate them to a high criminal standard, try them fairly, give them legal aid, convict them if it's the right thing to convict them, acquit them if it's the right thing to acquit, and so on. Do it. You see, this is an old man being regressive. But for me, that's what criminal justice and criminal law is about. It isn't about negotiated settlements, side deals, splitting the proceeds of crime and so on. That's what burglars do. They divide up the loot after they've left the house.
Well, I actually disagree with you on that. I think in the changing world, and you need to have a more rounded system to develop, to counter criminality. You can't have the cost of prosecuting everybody who launders money. You can't have the cost of enforcing all of our laws. If so, you would have the laws, every court filled for the next 20 years. But you almost do have that already.
You've got that.
But that's through a lack of backlog. And you would only prosecute a small amount of those who are committing crime. You'd also not stop the funds. because the bonus of account freezing orders is you're aiming at the money and taking the money out of crime rather than having to go through the criminal prosecution. So yes, you might not get the defendant prosecuted, but you're taking away the motivation for a lot of the crime.
Well, that's theory, but I mean, you're also taking away the stigma of conviction.
You might be taking away the stigma of conviction, but I know quite a few people I've worked with, defendants and clients, who would much rather their money and be keep their money and be prosecuted than have all their money taken away.
Well, it's very commendable of you, but you've got remarkably responsible client list.
my client list are not that well. My client list are a dynamic and interesting group of individuals. But I think you have to focus on the money. If you don't, we see that one in 4 pounds that go through the City of London were thought to be linked to unlawful conduct, maybe even higher. If you don't focus on that, you will not stop it. And I think it's been proven through the last 30 years that simple prosecutions don't get anywhere close to it. So though I would agree with you in principle, I think you need a much more dynamic set of laws, and account freezing orders seem to be at the top of that. The other way is I think DPAs don't focus on individuals enough, or making making boards more responsible. And another counter to that might be if we brought negligence into it, which was, as you mentioned, not brought in the Bribery Act, wouldn't that make trials easier? So you could go for trials rather than DPAs.
Yeah, I'm not going to go. It's too late in the day to swat that bait.
No, exactly, and it's a very it's a very double-edged sword. Can I just go to one of the questions we were asked? They're going onto the model of the Bribery Act. Switzerland are having a referendum about bringing in restrictions on following environmental laws and human rights laws, so that if those are not followed, the company will be responsible. Do you think that that's a model which we'll see expanding? So we've seen the tax evasion laws being brought in 2010 in response to the Panama Papers in the UK. Do you think we'll see much more laws looking at environmental restrictions and human rights? Monty, do you want to start us on that?
Well, I think it's inevitable if we go down the current ESG path, where companies want to appear to be virtuous, and the problem is this, though. So we have to start from the other end, don't we? So far, what we've got is an ESG movement, and we've got some very big players in the United States saying a profit motive can no longer be the main or sole driver of a company's affairs. But that's all very well. But in fact, in the States, they do have quite strong environmental laws. We don't. And they have also quite a muscular enforcement machinery in the States, and we don't. So first, you've got to build up your enforcement machinery. You have to have an enforcement machinery that says it's wicked and punishable to commit environmental offences. You've got to devise new criminal laws to illustrate where people are being antisocial or irresponsible from a societal point of view. And you've got to tighten up governance so that it is strictly enforced. And that's an enormous, enormous problem, particularly in the financial sector with financial regulation, because it's so complicated. And most people try and duck out of it. Most governments try and deregulate rather than re-regulate. So it's very difficult to go. So the answer to that is, I can't see how we're going to get an extension of corporate criminal liability to these concepts unless we turn them into offences.
Tina, what's your view on that?
Yes, well, I think we will see a much more use of a two-track system where we combine non-criminal regulation with criminal regulation. So that is something that is being done in many other areas, for example, in safety, many other areas where corporate misconduct can happen. And I think corruption, I think it is a problem when we use criminal legislation only. I think very often that is the best protection for those involved in the crime, because the burden of proof is so high. And I also think that a two-track system with clear legislation, so some countries do have it, and some countries have bribery legislation only in the non-criminal law. But I think those who have it only in criminal law, they have to introduce non-criminal manners to make it really efficient. And under non-criminal regulation, it is much easier to use negotiated settlements of various sorts, because then we don't mix it up with all sorts of criminal justice values that Monty is referring to. But the key is to have a system with serious benchmark penalties and clear, predictable benefits for those who self-report and cooperate. And most countries have a long way to go to make such a system work. So we have very good principles developed, and as of now, I think the United States is the closest in terms of using such incentives. But also in the United States, it can become better. So there has to be broad enough liability for the misconduct, and there has to be a system that rewards those who self-report. Because even if I totally agree with Monty that it is a benefit to have a serious criminal enforcement process, a proper enforcement process, when it comes to corporate crime, it's so difficult because we have so big corporations and they can hide the bribery in so many ways and make it impossible to hold individuals or the corporation liable. So we need to offer some rewards. The problem is that governments are unwilling to use the really big penalties when corporations have not self-reported and not cooperated. And I think that is something that we are waiting for, to see that governments are actually willing to sanction severely in the circumstances when corporations have not done anything to cooperate. So it's extremely important to have independent investigation, whatever non-criminal or criminal legislation. It's extremely important to have independent investigation in addition to a system that promotes self-reporting.
And going on to what you said, isn't one of the worries about that is giving prosecutors discretion, which can be a good thing, but it can also be, if there's not clear guidance or there's political pressure, can be a bad thing. I couldn't agree more that there should be a couple of test cases to go after bodies where they don't self-report and make an example of them. But circling back, with prosecutors' discretion, do you think that should be at the heart of the system, or would you say that there should be much more guidance given by governments to set out what they see is how these laws should be enforced? Tina.
Well, in order to benefit from this non-trial resolutions, some flexibility is needed, but I think there has to be clear principles for this form of enforcement. So I think in order to have a predictable benefit, as I just mentioned, we need to have not only guidelines, we need to have it very clearly stipulated, and also I think we need to have a transparent system, because as I mentioned in my talk today, it is extremely difficult in some countries to get information. And I had a research assistant working for several months on this project, and she wrote letters to the enforcement agencies, to courts, to the ministries of justice, and said this is for research purpose, and still they could not give us the information about the offences. They could only say that this company X paid a fine, this and that. So the UK is better than many other countries in this respect, but I think clear principles as to that secures the values, the criminal justice values in terms of transparency, a fair system, predictable system, that is necessary. We cannot have a totally discretionary system. In other areas, there's a lot of there's a big literature on capture, on how regulators can be influenced. And when we study corporate bribery, we should definitely be aware of the risk that also enforcement agencies and the politicians behind can be subject to such influence, and we shouldn't be naive and think that that cannot happen. And the more discretion, the more space there is for flexible solutions. And I also think that given these results that I pointed at, that there could be a tendency that crime is treated differently if the problems, the consequences materialize abroad. If that is the case, I don't think flexibility and discretion are the ways to go. I think we need to have clear principles for the ways this form of enforcement should happen. I think that is also necessary to secure credibility in the system.
Thank you. And Monty, I just want to go to the final question we have. It's asking whether debarment from asking for public bidding for public contracts should be part of the tools used in both DPAs and prosecutions. What's your view on that?
Well, it is in a way. I mean, it exists simply because we were, and I think we will de facto continue to be, part of the European machinery for debarment. The sections 1 and 2 of the Bribery Act provide on conviction for mandatory under our arrangements. Mandatory debarment, mandatory under 1 and 2, discretionary under Section 7. So that's, of course, one of the big driving forces for people to have DPAs or some negotiated settlement. Debarment is, we all thought it would be a very useful tool and it would be very powerful when it was first mooted, and it was used first in the States and particularly developed somewhere that Tina spent some time in the Royal Bank. And then, of course, we got this combined policy from the international investment banks who all joined together now to try and have a common policy on debarment. Obviously, when you're dealing with corporations who obviously have to make a profit no matter what the new ESG policy may be, they exist to make a profit for their investors. It's a terrible deterrent if you can't apply for public contracts. And in a couple of cases over the last few years, governments have actually retreated from that situation by trying to ensure that very important components of their economy, represented by particularly prominent companies, are not prosecuted, not only not by them, but by other countries around the world, not prosecuted in a way that would lead them to be disqualified. A very good example, actually, is the BNP, where the French government lobbied very hard for BNP not to be prosecuted. And in the end, they were proceeded against in respect of a very small subsidiary, which would mean that they weren't going to lose they were going to use their banking license in a very restricted and very partial way, but they weren't going to lose their license. And so they persuaded the US Department of Justice to proceed in that way. But so it doesn't matter what you do. And if I can summarize something, well, it's your job to summarize, not mine, but let me just anticipate your summary. Look, there are pros and cons to whatever you do. Not everyone can be prosecuted, not everyone will be prosecuted. No country can afford to prosecute everyone. You can't have a system which is fair but uncertain, and so on. We don't know whether people are deterred or not. I mean, we've got a very distinguished academic on this panel, and if she can find me some really great research which shows that whatever you do, it makes a difference, then I think that would be great. The unfortunate thing about being a practicing lawyer for the last 6 decades is that it appears that no matter what you do, however wonderfully it's trailed, however optimistic you are, and it's wonderful, the Bribery Act was a new dawn. It didn't work out that way because nothing ever does. I'm a very miserable person, but it's a miserable evening. It's dark out there, it's raining, and we're in the middle of a pandemic. You can't expect me to be upbeat about it. The problem is there is no silver bullet. There's vaccines may be great, but they're not silver bullets, and nobody's yet devised a criminal justice system or any part of it which is a silver bullet. All we can do during our life expectancy is to be fair and good to people, try and be just, and try and do the best we can with a very, very imperfect system because it's made by man.
Tina, what are your comments on it? But thank you very much for that, Monty. It's good summing up.
Well, when it comes to debarment, then we are back to the COVID-19 vaccine. We don't want to exclude companies that produce such vaccine.
Yes.
And it's also something that harms only those companies that sell something to governments. So it will not harm other countries. So in that sense, it could be seen as unfair. And given the EU regulations, where it says that the debarment is mandatory, it also says that it is up to the procurement agency to decide whether a deviation can be made. So it's not that mandatory at all. And when you look at the non-trial resolutions, you will see that in those cases, the companies promise never to do any crime again. And then that means that they are eligible for bidding on the same basis as other companies. And given the EU principles of fair competition and so on, the companies cannot be excluded from public procurement. That will not be acceptable under EU law. So that means that it doesn't function very well, but it is good to try out different approaches. But it should be remembered that that is under public procurement. It is not under criminal law. But apart from that, I want to say that there is a great evolution. Imagine where we came from 20 years ago, and the rules are improving, and the OECD is about to develop recommendations on non-trial resolutions. I think things will become more functional and predictable. And with the pressure from civil society, I think also that we will see cases both bring forward to court and enforced in other ways. So I'm a bit optimistic, and especially given the activities around the world on this issue, societies do not accept corruption. So I think on that note, I think there's a good positive development. And also many corporations want to see fair and good and just systems. So when considering this in policy settings, I feel that very often the corporations are as proactive as governments, and that is also something that is a positive development.
Well, thank you both very much for what has been for me a fascinating talk, and I hope for all our participants a fascinating talk. I think what comes out of it is the Bribery Act is a good thing. It's a world-leading piece of legislation, but it's also world-leading in the problems that it puts up, and it shows that where the errors are, where the issues are, and where the issues that need to be expanded upon are, especially this ongoing debate between criminal and civil prosecutions. I think we'll see a great rise in that. Is that a good thing? And where should the line be drawn for criminal prosecutions? But I'm sure we'll have a series of ongoing debates about that. Again, may I thank you both for your great contributions, and Colin King and the FinReg team for organising such a lively conversation. Thank you all for participating.